Okay. The next question. Explain your views regarding sentencing of an individual to rehabilitate community programs versus jail/prison. And Darren, we'll start with you.
Rehabilitation versus jail, was that the question?
Yeah, explain your views regarding sentencing of an individual.
Sure. Many good people make minor mistakes in life, and it's those types of individuals that reach out and want help, that need help, that are entitled to rehabilitation, entitled to probation. They make a slight mistake, their families reach out, they get the support of professionals in probation, and they work through the evidence-based programs. We're all in support of that. I think everybody is. It benefits the community that way. However, when you have someone who rejects the help, who is a repeat offender, a violent offender, they demonstrate by their behavior that they reject the help that's offered by our community. They don't want to reintegrate and become a productive member. That kind of behavior warrants punishment. It warrants jail or prison. They literally blown through their chances. I see it every day in court. I see people who are on probation 5 or 6 times keep on getting put back on over and over and over. Common sense says that's enough. Enough is enough. It is time to implement punishment or send them to prison.
Thank you. Chris, would you take that next?
Yes. So in terms of looking at community programs versus jail or prison time, other people who've spoken have touched on the reality of realignment, which has changed the types of sentences and the way that people can serve their time. As a judge, when you're looking at sentencing someone, and it's a very difficult decision. I mean, as an attorney, I would sit in court and think, well, that doesn't seem so hard. I mean, it seems kind of obvious to me. I know how I roll. I can tell you when you're actually making the decisions, it's quite a bit different. And you have to, when you start with the goal of sentencing, look at what is the goal of sentencing. It's punishment, it's deterrence, it's also rehabilitation. And there's a balancing act that you have to go through. If the only sentence that should be imposed would be the maximum sentence in every case, then we wouldn't need judges. The reason why we have judges is because the person who's making that decision needs to carefully consider all those factors and to make a decision about what is best based on the information that you have in hand, which is not always complete, based on the charges that have been filed, which may not have been the charges that you would have sought, based on the ability that you have to make a decision at that point. In looking at the impact of realignment, we have to also consider the fact that when you have a jail term and when we have overcrowding in our jails, I have to, as a judge, make a decision about what is going to give the person punishment, but what happens if I sentence that person and they're released tomorrow? Then there has to be something else involved in their sentence that's going to protect my community. It's going to help the person. It's going to give them rehabilitation if they wish to receive it. And so all of those factors have to come into play when you are making those decisions.
Don?
Thank you, Paul. First, let's lay our cards on the table. Where there's successful rehabilitation, there's less reoffenses. Anytime a defendant truly seeks help and is a good candidate for success, rehabilitation should be considered. But let's understand also that that doesn't always apply because the law requires many people to have rehabilitation programs based on the offenses that they've committed. And that being said, just because a defendant is initially eligible for rehabilitation doesn't mean that they have the right to continue if they fail to perform. At that point, the court should revisit their case and determine what punishment is necessary.
Thank you. Next question. What are your past experiences in dealing with cases involving civil, criminal, and family law cases? We'll start off with you, Chris.
Okay, so as a judge, I hear civil cases, I hear all of the civil law motion calendar, I hear civil cases through trial, settlement conferences, I hear the law motion calendar, and I also hear the small claims court and unlawful detainer matters. In terms of criminal cases, I see every criminal case from arraignment through trial for misdemeanors and arraignment through preliminary hearing for felony matters. I also sit on the appellate panel and consider writs. I have a Pelican Bay calendar every week. In terms of family law, I hear some of the family law calendars, all types of family law matters. I hear all probate matters, domestic violence, juvenile dependency, some delinquency cases. I have experience dealing with self-represented litigants. I was selected to serve as a family law facilitator back in 1997. I was the first family law facilitator, and as an attorney, I ran that program through 2012. As an attorney, I practiced for 21 years. I have civil law experience as an attorney in general civil matters, probate matters. I handled a significant family law practice, very complicated cases, was appointed to represent children by the courts. I've been involved in juvenile dependency cases for over 21 years as an attorney, and very, very limited criminal law experience as an attorney.
Darren, you're next.
For the past 17 years, I've processed probably about 10,000 hearings. I've handled, through those 10,000 hearings, hundreds of jury trials, hundreds of trials, and probably over 100 jury trials, all the way from arraignment to jury verdict. I've handled complex civil litigation trials lasting 6 weeks. I've handled juvenile dependency cases as well. I've handled family law divorces and custody hearings as well. I've even been the attorney for special districts and government agencies as well, writing ordinances in that regards. The big gorilla in the room, though, is 80% of our courtroom experience in this courthouse is criminal law. To have a limited experience is a problem. The vast bulk of what I've done is criminal law. Handled all the way from murder cases to DUIs, like I said, in every aspect thereof. I'm the only candidate that's certified to handle death penalty cases, all the way from the penalty phase to the guilt phase. I've learned that throughout that process that justice denied is justice delayed. I was speaking to Matt Farron. He happened to inform me that, and some of you may know him, that he caught a burglar in his house recently. After a tussle with that burglar while his wife was in the shower, the burglar was caught and brought to justice. In that experience, the current courts released the burglar without bail. He skipped court and has been out on warrant committing crimes apparently. He's been charged with new crimes. He's now back in custody. Matt feels that he's not treated fairly. The community is not treated fairly. New victims are not treated fairly. In my experience, that won't happen in my courtroom.
Thank you, Paul. We've already discussed criminal law to some degree. I've personally handled over 3,000 cases. The cases have been extremely serious, heinous crimes, murder by torture, rape, even juvenile delinquency murders, child molestation, burglary, manufacturing, methamphetamine, you name it, I've had experience in it. But I personally didn't feel that doing that was something that I felt was productive with my time and energies. So I switched over to the other side and I became a prosecutor. I was the prosecutor, as you know, of the Department of Interior for 6 years. I was and am city prosecutor, and
When the district attorney had a disqualifying event, I acted as special prosecutor in my instance. In civil law, I've handled all the types of cases that you would expect. I've handled injuries and death and property disputes and contracts and environmental suits and probates. But I've also had, through my representation of government, the big complicated issues that really take a high caliber of skill. And I like to think of it as family law is about this much, and criminal law is this much, and the rest of the bookshelf is about 20 feet, and I've got experience in all of those. In family law, I've represented both the divorces, attorneys, the children, the parents, child protective services, and I've done guardianships and conservatorships and adoption.